Mr. Shahdy Anwar moderated session 2 entitled Navigating Disputes, Unveiling the Layers of Multi-Tiered Dispute Resolution Clauses. The panel, Mr. Wong Hin Loong, Mr. Samuel Wong, Ms. Jessica Fay, and Ms. Mahnaz Malik, explored the advantages and disadvantages of multi-tiered dispute resolution clauses. These clauses have gained popularity for providing comprehensive dispute resolution frameworks. The discussion also touched on court and institution approaches to interpretation and enforcement.
Welcome back, distinguished guests, ladies and gentlemen. We hope you enjoyed your break. We'll now move on to our second session of the day, which is entitled Navigating Disputes, Unveiling the Layers of Multi-Tiered Dispute Resolution Clauses. Without further ado, I'd like to call upon Mr. Shahdy Anwar, the moderator, to kickstart the session.
Good afternoon, everyone. Thank you very much for all being here, and it's my pleasure to be moderating this very exciting panel with four of my very esteemed colleagues whom I would like to call. I would like to call Wong Hin Loong, fellow of SIARB, SIARB and MIRB with 23 years of experience in the field. I would like to call upon the next speaker, Samuel Wong, Council Member and immediate past President of HKIARB and Chartered Arbitrator. Okay. Jessica Fay, with over 30 years experience, is Global Co-Head of International Arbitration and Practice at King & Wood Mallesons. And we have joining online, Mahnaz. Okay, great. She's an arbitrator at 20 Essex, where she acts for a broad range of clients and matters, and fellow of Fusol Cambridge, and received the prestigious Legal Innovator of the Year award from the Financial Times. Thank you. It's a pleasure to be moderating this panel, and I think without further time, and I think we're sort of in between everyone and lunch, so I will try to kickstart things. So I would like to invite Hin Loong to first speak and give an introduction of the topic that we have. Thank you.
Good morning, everyone. Thank you very much for staying back for this event. Now, I've prepared some slides. I'll kick it off. I've been giving a 10 minutes time to do a short presentation on the multi-tier dispute resolution clauses. I've done some slides. Of course, I'll be going quickly through them. I can't finish all the slides, but I believe AIAC would share all the presentations after the event with all the participants. So please bear with me if I go a bit quick on the slides. Now, of course, as far as we know, the multi-tier dispute resolution clauses, commonly also known as escalation clause, is very common in construction contracts, JV projects, for example, where the projects run for a number of years. And of course, the main purpose of those clauses is, of course, you can see in the PAM contract, for example. All right, PAM contract 2018, it has a condition precedent. And you can also see in other samples like PWD, for example. You also have the multi-tier dispute resolution clause. And of course, you can also see it in other bespoke contract. For example, we have a requirement of good faith. So all these multi-tier clauses, essentially what it says that before you can actually commence litigation or arbitration, for example, you have to perhaps refer the dispute to a committee made up of the company representative of both companies, or in certain situations you have to refer to mediation or conciliation first. Now, the problem that we have in Malaysia is because we are actually not in harmony with the countries of other jurisdictions. Now, just to highlight, in Malaysia, what we have is the situation, the law have actually stopped developing in a certain way, which is to say, as far as the multi-tier clauses are concerned, it is treated as a condition precedence in Malaysia. We have the Juara Setara case, and of course the case of Usaha Sama by Justice Lee Swee Seng, which has been followed in subsequently about 8 Malaysian High Court cases. So the law in Malaysia is that it is a CP, you must fulfill this first before you can actually go for arbitration. What this essentially means is that if you refer your dispute to arbitration without fulfilling the multi-tier requirement first, whether mediation or conciliation or whatnot, the arbitrator, if it's challenged by the other side, what happens is the arbitrator is going to say, look, I have no jurisdiction to determine this dispute. I will have to dismiss this arbitration. So because you haven't fulfilled the multi-tier requirement clause or the escalation requirement. Now, so this would have very serious repercussions if you are acting for a client and you have a limitation period setting in, and if you have referred the dispute to arbitration, by the time the arbitrator is appointed a few months down the line, and then during the preliminary hearing, only the respondent raised the challenge, and then you find that your arbitration has been dismissed because you haven't fulfilled the requirement, and then you can't even start the process now because limitations have actually set in. So this is very different from the other jurisdiction. Now, in other jurisdiction, I've done some research on the law. We have actually departed from other jurisdiction, not departed, sorry, we have not moved along. In Hong Kong and Singapore and in UK, failure to comply with the multi-tier clause is treated as actually treated as a admissibility of claim issue, not a jurisdiction issue, right? Not a jurisdiction issue. What this means is that when it's treated as an admissibility of claim issue, that means that the arbitrator, if you go before the arbitrator, respondent raised a challenge. Look, claimant haven't complied with the multi-tier requirement. You haven't gone for mediation or conciliation yet. What the arbitrator can do during the preliminary meeting is to say, look, this is actually an admissibility of claim issue. I can still decide on this. And since the claimant have not complied with the requirement, tell you what I will do. As the arbitrator, I have the power. I can stay the arbitration proceedings. Parties, go and comply with the multi-tier requirement first. You go and do your mediation, conciliation. Tell me what is the outcome 3 months down the line, 2 months down the line. In the meantime, I'll stay the whole process. And then in that case, parties will come back after 2-3 months. So it's actually an admissibility of claim issue. So the arbitrator have that power. But if it's a jurisdiction issue, then the arbitrator in Malaysia will have to say, I'm sorry, I have no jurisdiction to decide this at all. I have to terminate the arbitration proceedings, or I have to dismiss the arbitration proceedings. So it's a very serious repercussion in Malaysia. So perhaps it's time for Malaysia to look at this issue. These are the case laws in UK, in Singapore Court of Appeal, and in the Hong Kong Court of Final Appeal, which was just decided in 2023. So seriously, I think it's time for our judiciary to also look into this issue so that we are in line with the other Commonwealth countries. It's treated as an admissibility of claim issue. Now, useful guideline can be seen, for example, in the International Arbitration Practice Guideline issued by CIARB, jurisdictional challenges, which can be downloaded online. The latest one is in November 2016. So this CIARB guideline on international arbitration practice actually sets up jurisdiction challenge, how the arbitrator should deal with it, whether it's an admissibility of claim issue or jurisdiction issue, and whether the claim is ripe or is premature, and what the arbitrator can actually do. And of course, CIARB recommendation is that it's treated as a admissibility of claim issue. Then the arbitrator still have the power to decide what is the best thing to do in that scenario. Now, very quickly, I just want to run through some recent cases in Malaysia that to illustrate how serious the problem can be in the context of Malaysia. We have the 2020-21 Tokyo Marine Insurance case I'll have to skip through the rest, right? As I mentioned earlier, I believe the slide should be shared with the participants later. If not, then please feel free to email me or add me on LinkedIn and whatnot. I'll be happy to share the slides. Now, Tokyo Marine Insurance, this is a 2021 case. Now, what happened here is, of course, the plaintiff here have actually filed the suit, right? They have filed the suit. Now, and then there was, of course, non-compliance with the multi-tier dispute resolution clause. And of course, the defendant applied for a stay order under our Malaysian Section 10 of the Arbitration Act to say, look, there's an arbitration clause, so you have to refer the dispute to arbitration. So the court issued a stay order under Section 10, and when the dispute was referred to the arbitration, during the preliminary meeting, the defendant, respondent, issued a jurisdiction challenge under Section 18 of the Arbitration Act. The arbitrator was a very eminent and well-known senior lawyer and senior arbitrator. He was here, in fact, in the conference yesterday. So when the challenge was raised, he said, look, there's a multi-tier requirement here. We are supposed to go for mediation, and the plaintiff have not complied with the requirement. So what the arbitrator did was, he actually decided that he have no jurisdiction. He actually dismissed the arbitration, or he terminated the arbitration proceedings. By that time, even earlier, the plaintiff's claim is already time barred. He cannot even go back to comply with the multi-tier requirement anymore. So what the plaintiff did in Tokyo Marine Insurance, he actually went to the High Court to try to set aside the award under Section 37 of the Arbitration Act. That was the only thing the plaintiff could have done. Now, what the High Court Justice Liza Chan held in this case is that he said, look, the plaintiff could have, in the stay proceedings under Section 10, when it was being argued before the High Court, he could have sought a waiver of the condition precedent of the arbitration agreement, or could have sought a suspension of the limitation period, or an order to preclude the defendant from raising the defense of limitation. None of this was actually done. Now, what the plaintiff tried to argue in Tokyo Marine Insurance is that, look, when a defendant applied for a stay of proceedings, they never say they want to refer to the multi-tier dispute resolution clause. The plaintiff said, my understanding was, they applied for a stay of proceedings, they want to refer the dispute to arbitration. But when they went before the arbitrator, then only they raised a challenge. Oh, plaintiff haven't complied with the multi-tier resolution requirement. But what the High Court actually decided in this case was that, look, when the defendant filed the affidavit in reply, they said, at all material times, the defendant is willing, ready, and able to comply with all the conditions contained in the agreement between the parties. And the High Court said, the conditions in the agreement of the parties says there is a multi-tier dispute resolution. So the defendant is perfectly correct. He never misled the court. They were prepared to comply, and one of the requirements was the multi-tier dispute resolution clause. So on that basis, plaintiff's application to set aside the award was dismissed by the High Court, and the plaintiff's action was actually time-barred, too late for them to go and comply with the multi-tier dispute resolution clause. So this is a very serious issue for Malaysian lawyers and also the legal councils in Malaysia, because we are not in harmony with the other Commonwealth jurisdiction. So what can we possibly do? Now in Malaysia, we have two High Court decisions, as far as I can see, where I'm not sure whether in other jurisdictions you have that sort of power, which is actually found, if I can go back, power of the Malaysian courts to suspend the limitation period for arbitration proceedings. Now this was first done in the case I mentioned just now, Usaha Sama case, where here the High Court, this is the leading case in Malaysia, actually upheld the condition precedent where parties have agreed to refer any dispute to the SO before referring the said dispute to arbitration. Now, of course, here the plaintiff or the claimant raised the issue, look, there is an issue of limitation. If we go and comply with the multi-tier requirement, by the time we comply with all that, 6 years limitation is in, we are dead in the water. No, we can't go for arbitration anymore. So here, the High Court actually suspended the limitation period from the date the application of the preliminary issue by the parties was made before the arbitrator, pending full satisfaction of the CP. So the period of time, what the High Court did in this case was that the period of time when parties are before to comply with the CP, that is not taken into account for the limitation. They suspended the limitation period. And in another case, right, the Apex Marble case by Justice Nantabalan, as his lordship then was. So in this case, there was a stay under the usual Section 10, stay of proceedings, pending reference to arbitration. Now, Section 10, Sub 2 of the Malaysian Arbitration Act gave very wide powers to the court to impose conditions when the High Court is going to grant a stay of proceedings. So what the defendant here have actually raised again is say, look, we have a serious problem of limitation. If we go back to comply with the multi-tier dispute resolution clause, by the time we comply with it, we are already time barred. 3 months down the line, we are time barred. And then what the High Court did was they granted a stay. So the High Court said, yes, I recognize there's a problem of limitation. So I'll grant you a stay of proceedings, but here you cannot raise. So you cannot raise the defense of limitation in the arbitration proceedings. Precluded. So the party is now precluded from raising the defense of limitation in the arbitration proceedings. So this is how I can see the way the Malaysian courts try to assist the parties how to bypass the issue of limitation in the context of Malaysia, because it goes to the issue of the jurisdiction of the arbitrator. If the High Court do not exercise its power under these provisions, then of course the claim may eventually be time barred or will actually be struck out because there's issue of limitation setting in. So in future, the parties, the Malaysian litigants, counsels or in-house legal counsels, when you are faced with this type of issues, stay of proceedings under Section 10 or any issues before the court, you must bear in mind that the onus or the burden is on us, if we are actually the claimant or the plaintiff, to make the applications to the court to suspend the limitation period, if necessary, to protect your client's interest. If you don't do it, then you end up in the situation of the Tokyo Marine Insurance case, where the court says, too bad, you could have asked for this ancillary relief. You did not. So the court just granted a normal stay. You didn't ask for it. And that is the end of your multi-million claim. So the key takeaways of that is to make sure when you look at the multi-tier dispute resolution clause, be careful of the timeline and what you need to do to protect your client's interest. You could have the best claim in the world, best documentation and whatnot, but if you do not comply with the multi-tier dispute resolution clause, that's it. That is the end of your claim, no matter how strong your case is. So that would be end of my presentation. Thank you very much.
Thank you, Hin Loong. I think it underscores the importance of sort of following the procedure. I mean, I think with respect to a multi-tiered clause, it is inherently an additional procedures. And I think as also highlighted from the session above, Darshan Dev, your sessions as well. I mean, I think the ultimate idea may be to avoid a dispute. But ultimately, we all have to agree that, at the end of the day, most of these claims will end up in dispute. And where it ends up in dispute, if we have a multi-tiered provision where it's designed to make it more efficient and easy for you, but nevertheless, if we sort of miss out on a provision, then we may lose out. I think, Samuel, what are your thoughts on these challenges to multi-tiered provisions as well, especially on admissibility versus the jurisdiction challenges? What are your thoughts and experiences?
Yes, I would actually address the Apex case in C&D. That is a judgment of the Hong Kong Court of Final Appeal on the issue of admissibility and jurisdiction. But I would like to go back first and go into to address generally the matter of multi-tiered arbitration, if I may. Nowadays, many arbitration or dispute resolution clauses started with a step by the parties to negotiate or mediate before arbitration. So depending on the wording of that dispute resolution clause, such stipulation may become, such stipulation actually is useful so that disputes can be resolved more expeditiously without unnecessary legal costs. However, such wording, depending on how it's written, may become a precondition to the commencement of arbitration, a step that has to be undertaken, and that may result in additional costs and time in respect of the resolution of the disputes between the parties. So I would like to take you to some actually dispute resolution clauses. Some are permissive of negotiation or mediation and not mandatory. Others are mandatory, requiring first step before you can go for arbitration, while others impose the condition of a notice in writing to the other side to commence the period, for instance, of 60 days. Other clauses does not impose a condition of a written notice to commence the period. So with these varied conditions, one may face different difficulties. We find even in BIT, bilateral investment treaties, such as between Finland and China, the BIT Article 9 stipulates that the contracting parties should, if possible, settle amicably before commencing an arbitration. And so and then if the parties fail to resolve the differences, then they may go to exit arbitration or go to an ad hoc arbitration. So the aggrieved investor in a foreign country can have access to these ways to resolve differences in relation to their rights under BITs. Now, in relation to the first tier steps to be taken, we say that actually one of the difficulties that we face sometimes is whether a written notice has been given. If no written notice has been given by one side to the others to commence mediation or negotiation, how does a casual oral notice of some dispute, whether they can start the period of 60 days to run? And failing that, there is uncertainty whether that first tier provision has been complied with. So for practitioners, actually, it would be good when you draft these dispute resolution clauses to draft it with clarity, requiring a 60 days written notice so that the parties would know precisely what they have to do to comply with the precondition, if it is a precondition. Now, the second is a requirement of negotiation or mediation in good faith. What is good faith negotiation or mediation? How do you measure that? And is that enforceable? Now, previously, some English cases such as Watford and Miles mentioned that the concept to carry out negotiation in good faith is inherently repugnant to the adversarial position of the parties involving in the negotiation. However, that is a special case that is different from other cases whereby there is a concluded contract with a good faith negotiation clause therein, requiring the parties to perform in a certain manner. And in a Singapore case, Justice of Appeal V.J. Raja has this to say in the case of HSBC, Institutional Trust Services versus Toshin. He said this: in our views, there is no good reason why an express agreement between the contracting parties that they must negotiate in good faith should not be upheld. And then he continues to say that indeed, we think such a negotiation in good faith clauses are in the public interest as they promote consensual disposition of any potential disputes. And then he commented further, we note, for instance, it's fairly common practice in Asian businesses to include similar clauses in their commercial contracts. I note that in numerous Chinese contracts between the Chinese parties and another party always put in a good faith negotiation clause to negotiate good faith before commencing arbitration. And then what is good faith negotiation? And we see that there's a judgment by Lord Justice Leggett that mentions the usual content of the obligation of good faith is an obligation to act honestly with fidelity to the bargain, an obligation not to act dishonestly and not to underline the bargain entered into. So there is a requirement. Firstly, I think it's important, what is good faith? And then importantly before that, whether a notice has been served. If the notice has not been served, that brings uncertainty as to whether the first step has been taken, the first tier. Now, there are challenges to arbitration awards arising from multi-tiered arbitration. We have a case, a recent case of the Apex Court in Hong Kong, the Court of Final Appeal by 5 judges, as to what my learned friend has mentioned as to the admissibility and jurisdiction issue. The challenge, this dispute arises out from a multi-tier arbitration clause between two providers of satellite transmission services. One a Thai company, the other is a Hong Kong company. The arbitrator, one party raised an issue as to whether the notice of the first tier has been complied. The tribunal did not rule that as a preliminary issue, but determined that in the arbitration award. And as a result, the arbitration award is challenged on the basis that the tribunal has not followed the procedures agreed by the parties, acted beyond its jurisdiction, and therefore the arbitration award should be set aside. Now, this actually challenge went through the Court of First Instance, the Court of Appeal, and then finally landed before the Court of Final Appeal of 5 judges. Just to highlight the background, actually, courts generally, under ancestral model law, has limited jurisdiction to interfere in an arbitration. And in Malaysia, this is provided for in Article 8 of the Malaysian Arbitration Act, that has actually mentioned in matters governed by this law, no court shall intervene except as provided in this law. That means the arbitration ordinance. Also in Malaysia, in Arbitration Act, Article 18, also adopted Article 16 of ancestral model law, the competence and competence rule, making it competent for the tribunal to rule on its own jurisdiction. And it provides in Article 16, subsection 3, that the tribunal may rule on a plea in this article as a preliminary issue or in the award on merits. Therefore, it's up to the tribunal whether they deal with it as a preliminary issue. Now, another relevant article is Model Law Article 34 that provides for the exclusive grounds or the recourse to set aside the arbitration award, save as this is corresponding to Malaysian Arbitration Act, Articles 37(1)(a)(4). So the question is whether the challenge is actually to the jurisdiction of the tribunal or to the admissibility of that particular arbitration to be heard before the tribunal. Whether the award is subject to curial review. So this matter of admissibility and jurisdiction has actually been dealt with quite a lot in Singapore Court of Appeal in the case of BBA versus BAC. I will not go into that. The end of the day, the result is actually analyzed on a consent basis, what the parties has agreed to in relation to dispute resolution by arbitration, because arbitration is a consensual process. Whether it's a challenge to the tribunal's jurisdiction, or whether it is a matter of whether the matter is admissible, or whether the arbitration is premature. Now, in the case C&D, I have set out the dispute resolution clause at page 21 of my PowerPoint, and I would not recite that. It's for the parties to attempt in good faith to resolve it. Failing amicable resolution within 60 business days of a party request in writing for negotiation, then it shall be arbitrated in Hong Kong under HKIAC using UNCITRAL arbitration rules in force. Now, in this particular case, construing the dispute resolution clause, the Court of Final Appeal in Hong Kong find on true construction of the dispute resolution clause, the tribunal had found that arbitration precondition had been complied with. And the parties, by the arbitration clause, were happy to have the dispute dealt with exclusively and finally by the arbitral tribunal. So actually, not everything is subject to curial review. If the tribunal finds that it has jurisdiction, then under model law and actual Hong Kong law, the court could have a review over whether the tribunal do have jurisdiction. So the party can argue that. But if it is not a jurisdiction problem, the court have no jurisdiction to review, because the court of the jurisdictions, the court's power is limited to what is permitted for it to review under the arbitration ordinance, or in Malaysia, your Arbitration Act. And in Hong Kong, in the Apex Court judgment, it found that the jurisdictional and admissibility distinction is very useful for courts to consider whether curial review is engaged. And then admissibility challenge, whether a step has been taken, is a matter for the tribunal to consider and decide, and it's not for the court to decide. And pre-arbitration conditions generally are presumed to be non-jurisdictional unless the party with express word in the dispute resolution clause specified that such disputes are reviewable by court. Otherwise, the court, Hong Kong courts, will have no jurisdiction to look into it. And then, whether the dispute resolution clause and the terms of submission are to be looked at is to be determined by looking into the common intention of the parties when they enter into the dispute resolution agreement. And by that, we should draw reference to the judgment of Hoffman in the case of Fiona Trust. And finally, the availability of judicial review is whether you can have recourse to it to set aside the arbitration award is ultimately dependent upon the proper construction of the parties' arbitration agreement. So, in general, you would classify a precondition as an admissibility issue, therefore not subject to review. So, if you want to have it, you should consider and draft your dispute resolution clause very carefully at the outset. So, what we can take away from this is that when drafting a multi-tiered arbitration clause, counsel for advising the party should be very careful in drafting it. In drafting it, I think to avoid uncertainty, you should mention expressly whether mediation or negotiation is optional for the parties to consider or mandatory, so permissive or mandatory. And if it is permissive, then it may not trigger the first tier as a precondition. Now, if you want it to be mandatory, then you should specify clearly whether notice in writing is required. And it would be useful to have a requirement of written in notice so that there's no uncertainty as to the start date of the period counting from that date to the day when agreement or settlement is not reached and the party would have to resolve to arbitration to settle their disputes. So this is what I have for this audience today. Thank you very much for your attention.
Thank you, Samuel. That was very interesting insights. Jessica, what is your experience from a Chinese perspective being on this issue?
Okay, thank you. Before I start, I'd like to, say how pleased I am to be here after at least 4 years. I think looks like everyone probably has not yet forgotten what we have experienced and undergone in the past more than 3 years. And actually, this is my first trip to Malaysia and going to be in Singapore as well after 4 years. Kind of blocked down, of the cross-border travels. So I'm so pleased to be here to see people, to meet people in person. Okay, now I turn to the perspective of mainland China. We have heard our speakers discussing about the Malaysian approach as well as Hong Kong court decision. And the Hong Kong court decision in the C versus D case has been quite widely discussed in the arbitration circle, where the Hong Kong court distinguishes between admissibility versus jurisdiction. Of course, it is a very important decision to support jurisdiction of the tribunal, of the arbitration institution. But still, it concerns admissibility. And as practitioners, I think we all know admissibility is also important. What if, although it is an admissibility issue, but if the tribunal says this claim is not admissible, then you are stuck? Or whether the tribunal will allow you to fix it, to suspend the arbitration proceeding, to go through the so-called 30-day or 6-day period of negotiation before commencing. But if I'm acting as the opposing counsel, why should I agree with that? Because you have already commenced arbitration. Can it be fixed just by saying, with the suspension of 60-day negotiation now, after commencement? If we talk about technical issues in this strict sense, this cannot be fixed, right? It has to be this claim or this arbitration has to be dismissed or withdrawn, and then you go back, negotiate, and come back after the requirement is satisfied. So just as a starting point, I think as practitioners ourselves, either act as counsel or arbitrator, this is a very realistic issue that we have to consider and face. So if we can advise client to avoid that dilemma and difficulty going forward, we should try to do it, to prevent it in the very beginning. With that, I think I want to summarize very briefly the position and stance of the PRC courts. The PRC courts, as you know, PRC law or mainland Chinese law is very much based on civil law tradition. It is unlike common law legislations in Hong Kong or unlike Malaysia. And for Chinese courts, I think they normally adopt a rather broad brush approach in assessing issues. We don't see any kind of clear distinction between admissibility and jurisdiction. Very often the court will just say this is a jurisdictional issue or not, rather than distinguishing admissibility, etc. And as we have discussed, as we are sitting here in Malaysia and in Asia, part of Asia, in China, it is quite common, as Samuel has mentioned, for parties to include in its dispute resolution clause some wording like, if disputes arise, parties should try or make best efforts or good faith negotiations, and failing which either party can submit for arbitration, which is something quite typical in drafting a dispute resolution clause. But whether that should be construed in a strict way, or just like, to show an intention, a willingness to negotiate before dispute resolution process, I think the Chinese court's position is that is not mandatory in general, because it is so easily put in the drafting, rather than saying, you have to comply to make it a condition precedent or precondition. So normally, even if, for example, as I mentioned, the clause says failing by friendly negotiation and failing settlement, parties can submit for arbitration, and Chinese courts characterized the first so-called condition of first tier of friendly negotiation as merely a procedure requiring the formality of negotiation. So it's only a formality requirement rather than a mandatory or a precondition requirement, and will readily deem the second condition, i.e. failing settlement, as readily fulfilled by the act of filing for arbitration. So if one of the parties decides to go for arbitration, that itself demonstrates that parties have failed in their negotiation or failed settlement efforts. And this actually has been confirmed in a guidance note issued by the Supreme People's Court in 2008, and has been largely followed by the lower courts since then. And we have also discussed the other clearer kind of requirement for, let's say, for 60-day negotiation period with written notice. That is, of course, compared to the earlier version, it is more kind of clearer, and sounds like more mandatory. You need to do something to start the consultation or negotiation period. And this kind of clause was the position of the PRC courts. The court's view on this point evolved actually over time. Now, from the cases we have researched, it looks like that they treat the time limits as formalities without jurisdictional consequence. So they don't really treat that as precondition or mandatory requirements. It's more formalities. You can, for example, one of the courts has decided in its judgment that since parties have proved that they have been in discussion, in negotiation of the disputes for some time already, can be over a year, so there is no need to stress that you have to go through this so-called 60-day period of further negotiation. So that has been largely treated by the courts as formality of procedures. And of course, you might have heard one of the cases in China in the early days, 2007, there was a Pepsi case where the Stockholm SCC award was not enforced, and also with consent from the SPC on the ground that parties did not satisfy the 60-day negotiation period, although the tribunal had addressed that issue in its award and saying that it was satisfied, or they considered there was no issue. But that case was, I would say, could be a special case for special joint venture disputes, but that has not really been followed. But still, I would like to flag the risk. If you have express requirement for 6-day consultation or negotiation and you didn't comply with it, there is always risk, because the enforcement, when enforcing an award, you may go to different jurisdictions, and the courts may have different views towards such procedural issues. So as practitioner, it is still advisable to make sure you don't face that difficulty down the road. So I think, generally that's the common stance and approach of the Chinese courts. And what arbitration commissions do, because in China, the other characteristic is when the claimant run to arbitration commission to file a case, the arbitration commission normally will really review the case in a little bit detail to ascertain the arbitration clause, etc. It's unlike HKIC or other like more common law jurisdiction where the acceptance of case is quite straightforward, not much of any review by the institution. But Chinese Arbitration Commission will, they will check the arbitration clause, and if they spot a requirement for that, they will ask the claimant counsel, the claimant, have you satisfied that limit of the condition? If not, they say, you better go back and fix that and then come back to file the case. Or if the party insisted to commence arbitration immediately, they may ask that party to sign a commitment letter saying, I assume all the risk associated with that issue. So that's actually in practice, what will be done. And as a last point, I'd like to, as takeaway, to share with the audience here, I think my personal view is where, unless it is really needed or necessary, you don't make a mandatory requirements for prior step negotiation, because that actually can, I think, incur a lot of not just time and cost, but huge issues. While I was preparing this and hearing my co-speakers, co-panelists discussion, I'm thinking loud, and also this is a question for the audience. What if you need urgent assistance from the tribunal, from the arbitration tribunal? For example, we have the emergency arbitrator mechanism. What if you want to go to court for interim applications, for asset, phrasing order, and these kind of very urgent measures you would want to have, but when you are facing a 60-day negotiation period and with written notice, how could that be resolved? And if you go to the court for interim application, there is always a very short period, time limit for you to file the arbitration case to make that phrasing order, valid. Otherwise, it will be lifted. So there are, I think, multiple issues. If you have made your first-year negotiation requirement mandatory. Thank you.
Thank you, Jessica. I think we've sort of been delving very much into the details of issues that come across due to the drafting and the mechanics of how we actually do multi-tiered provisions, and perhaps the pitfalls of the multi-tiered itself. If the steps itself are mandatory. I would now perhaps like to go slightly back, not into perhaps some of the details, but maybe Mahnaz, you've been joining and listening into our conversation. Perhaps you can sort of maybe go back a little bit and enlighten us on the use of sort of these multi-tiered provisions, how it sort of ties into cross-border investment agreements. I would leave the floor to you all. Thank you.
Thank you so much, Shahdy, and a good afternoon to all of you. I'm very sorry I'm not here in person. As you can see, it's probably just dawning in London as I speak. So thank you again for having me virtually. I appreciate that lunch is around the corner for you, so please forgive the analogy I'm about to adopt. Multi-tiered reminds one of a cake, a 3-tier beautiful cake, and you can ascribe whatever flavors or colors you'd like to the tiers of this beautiful cake. Now, I say cake because in any cross-border investment, there are 3 tiers or perhaps tracks of dispute resolution fora that one needs to consider. And depending on the importance of these dispute tiers, you can decide where it fits into this 3-level cake that I've just described. So to my mind, the bottom layer of the cake, the biggest layer of the cake, has to be the national courts where the investment is based. Everyone, presumably, has the right to go to the court for various reasons. You could have a dispute with a provider that is not premised in contract. You could have contracts that refer to the courts themselves. Your employees could get into a criminal action, which means you might end up in court. You could yourself be, as a business, the respondent in a tax or another criminal investigation. So the reality is the national courts of wherever your investment is based will always have some form of a relevance. And I think it was Jessica earlier who spoke about interim relief. Of course, even if you have contractual claims, the courts of where the actual asset is cited will always have a relevance. And hence my proposition that is probably the biggest layer of the cake, the bottom layer, as I call it. Now, the second tier is arbitration. And here I emphasize that the arbitration provision, probably in a large cross-border investment, will lie in several places. You will have contracts with your business partners, contracts with your providers, contracts with your suppliers. Most of them will have international arbitration contracts, agreements that will be cited in other parts of the world. It could be that you decide not to choose the seat of the country where you're based. You could be in Malaysia, but the seat could be in London. You could have various laws governing that particular contract. And I see this as the middle tier, slightly smaller than the bottom layer, which takes you to the courts. And the top layer of this particular multi-tier dispute cake that I've just created is the bilateral investment treaties. There are over 3,000 bilateral investment treaties that offer a dispute resolution system. Malaysia has over 70, China has over 130, the UK has a similar number. You can check the jurisdiction where you're investing and count the number of treaties. Now, what does that mean? I think one of the speakers earlier referred to bilateral investment treaties and mentioned that these treaties also have a notice period before you trigger the dispute. I will come to that particular point in a bit. But the point here is that you have another dispute resolution mechanism that is not subject to a contract. It is there for, under international law, for investors to invoke if they qualify. But the reason why my top tier is so narrow is that bilateral investment treaties can only be used to bring disputes or claims against state entities. States themselves rather than state entities. So they can only be bought. They can only be bought to use to bring claims against the state itself. So you can't use bilateral investment treaties to bring claims against private entities. And that's a really important restriction. So you've got your three-tier cake now. You've got the national courts, you've got arbitration and private contracts, and then you've got the bilateral investment treaties with the option of taking the state to international arbitration. What does that mean? Does it mean that you have to work through this tier, starting from the bottom to the middle to the top? Does it mean that you can be greedy and go straight to the top and pick the bilateral investment treaty claim? Or does it mean that you can go in the middle of the cake and start eating it? The answer depends on the dispute. And this is why it's really important to zoom out, I guess, for want of a better word, to really look at how these systems interconnect, to ensure that by using one forum, you don't create problems for the other. So take, for example, if you decide to go to the national courts in relation to, say, your tax complaint, your tax claim against the state that you say was unfairly brought against you, and eventually you believe that you have a bilateral investment treaty claim to challenge this. What happens if you go to the court, the national courts, to try your luck first? Does it mean that you're then denied the ability to bring in bilateral investment treaty claim because the state Supreme Court has decided the issue? Or does it mean that you can still do it? In fact, you've displayed good faith by trying the national courts before. And the answer to this question depends on looking at the clause, looking at the investor-state clause in the treaty itself. And if you look carefully, you'll probably see two variations. I mean, there are many variations, but I'm just pointing out two common ones for you to look at. One will say, well, there should be good faith efforts. As one of the speakers earlier pointed out, you spend 6 months or 3 months or 12 months, and you attempt to resolve that dispute by negotiations with the state. Now, it's very important to say that what it's really requiring is negotiations with the state. It's not requiring that you try your local courts or the state's courts to try and solve it. What happens if you do that? Can you still go to arbitration? That is where the problem often lies. You might have what we call a fork in the road clause in the treaty, which says, well, you have all these options available. You can go to the national courts, you can go to contractual arbitration, but if you choose one, you can't go to ICSID or investor-state arbitration. So if you brought your claim in one forum listed in the options, you can't go to the international forum. So, tip number one is whenever you have a dispute involving an international investment and you believe that you might have an investor-state claim against the government, be very careful about what remedies you invoke in this case. If you use the local courts against a state party, then be aware that the treaty might prevent recourse because it might hold you to the fork in the road. even if there is no fork in the road, I think it is quite important to handle these issues delicately. Take the situation where you have a tax complaint, for example, to use my previous analogy, and the Supreme Court has ruled on the issue under the national law of the state you propose to then sue later on. But there are two immediate impediments. The state can't probably go against the decision of its Supreme Court and grant you a settlement contrary to its own law. Second, you have issues of re judicata. You've submitted a claim in your own volition, albeit under the national law. What does that mean for the BIT claim? And finally, what about a binding precedent under the national law? So in Commonwealth countries, we have binding precedents. So if the claim has been ruled on by a highest court, that matter, to some extent, is settled under the national law of the state. So if you then bring it to an arbitral tribunal, and if that contract, and I'm not talking about treaty, if that contract is governed by national law, what does that mean for the tribunal applying that national law to that issue when national law has already been settled on that very issue by the courts of the state where you submitted that claim voluntarily? So just stepping back, as Shahdy said, you have to be very, very careful in designing your dispute strategy, because whatever you do at various stages will impact. Now, before I sort of round this off with some closing comments, I also wanted to flag up the contractual claims between private parties and their impact on BIT claims. If you've recovered your losses or you have a claim going against your business partner, but then you also want to bring a claim against the state, there'll be issues of loss and compensation and double recovery. Often, you also have a contract with the state, and it is becoming increasingly common for investors to try their luck on two gambling tables in the same casino, as someone once said. You try your ICC arbitration, your commercial arbitration against the state in one forum, but then just because you have the ability to bring a investment treaty claim, you also bring that, and then you see which horse gets to the finish line more. That is also, I think, a dangerous strategy, because there are questions of parallel proceedings, lay pendants, but at the same time, there are few tribunals, believe it or not, that have stayed one action in favor of the other to close. So often these proceed in parallel, and remember, the investor has to just win in one to win overall, whereas the state would have to defend both, because the state is typically a respondent in an investment treaty claim. Now that sort of sets, the list of potential dispute forum for an investment. My parting comments were really, what if you don't have the choice? What if you as an investor end up in the first tier of the cake, the local courts, because there is a criminal investigation or a negligence action or a tax authority where you are the respondent? So you have no choice but to respond and have those issues tried in a national court. And there, I would say, immediately, please seek legal advice, because there will be implications for your contracts with private parties and the arbitration clauses, especially if those disputes provide for the application of the national law. I mentioned binding precedent. I mentioned issues of law that then might come and haunt you in even a commercial arbitration. And second, be well aware of any obligations that you might be able to invoke against the state in their treaties, and decide when is the right time to invoke those treaty actions. Do you even want to participate in the national court proceedings if you believe that those won't be fair and may, in fact, then jeopardize any rights you might have under the treaty because you've inadvertently participated? Or do you reserve your position and you ensure that those rights are not compromised in any way as you participate if you are required to do under the law? So I hope I'm well in time, Shahdy, and I haven't overstayed my virtual welcome at least, but I'm very happy to take any questions later.
Thank you. Thank you, Mahnaz. I think, just sort of going back to, the construction of the provisions itself, just put a question to the panel. How would you then determine the most effective sort of structure and progression of a multi-tiered course? Maybe, Jessica, would you like to share your thoughts?
I think this is it's a good question and challenging one. How to design a really effective multi-tier clause. Frankly, I think, depending on whether you really, as I said earlier, whether you think the so-called first tier or prior tiers could be first tier, second tier, and then you go to arbitration. Whether you really need these prior tiers, prior steps, and that would be if you really need them. For example, in particular in construction disputes, project disputes, the DAB adjudication kind of process, and how I think the parties and their counsel needs to pay more attention in the drafting, in first to discuss and explain and ascertain what they really need prior to serious contentious proceeding like arbitration, and whether that will be fruitful or helpful to both parties. And of course, sometimes I think, depending on which party, who is your client, whether you want delay or not, you may design different clauses, while the other party may have that kind of, may not be paying attention, just think they're just copy-paste something. But I do think, you need to consider carefully as to, I think that's actually the caution from this panel. If you want to include any mandatory or condition precedent as steps prior to arbitration, you need to be extremely careful and pay attention to what you really want and what you want to achieve. For example, in one of my current cases, it is a construction project related case, and one party went to arbitration first, and then there was a objection, jurisdictional objection, because there should be a DAB process first, and then party went back to DAB process. And now in DAB process, and the procedural timetable when I was first involved really astonished me, because each party is taking about a year to put forward their kind of filing of statement of claim, and then another year to reply. So I'm just thinking, this process can take 3 to 5 years alone. Is it effective dispute resolution clause at all? And for this DAB board, all the members would be like with legal backgrounds rather than engineers for some technical issues. So 3 lawyers, on the panel, and then deciding an issue after, let's say, 3 or 5 years, and which can be further challenged in arbitration. So whether this is something the parties really intend to have, because not just about cost and time delay. And also, I note that Hin Loong also mentioned about time bar issue, time limitation issue, and of course, efficiency is another big issue. do you really get your money back in 5, 10 years? And whether that owner or contractor is still alive by then? So I think, time and cost and efficiency is a huge issue. If you want to build in some prior steps to make it mandatory, think carefully and make it, I think, very efficient. And really, or some parts of it can be, for example, some technical issues. Parties may agree that if we agree to go through this process, some decision is binding. For example, then you don't need to dispute that whole issue again in arbitration. So that's actually, I think, my preliminary advice on multi-tier clause drafting.
Thank you, Jessica. I think you highlight the problem in one sense where, as lawyers who draft, who are you advising and what are you trying to achieve in terms of, are you trying to achieve efficiency or are you trying to achieve delay? Maybe in one sense, delaying is in your client's interest. So, I mean, kind of that leads me to what I wanted to discuss after this. How do we avoid such delays? I mean, where there's a multi-tiered provision, perhaps designed by lawyers who intend there to be delays, and in such an instance, how do you deal with it? Maybe you have some thoughts.
I mean, after reading all the case laws from Malaysia and other jurisdictions, and from my own dealings with multi-tier dispute resolution clauses and with my own clients, my first view now is that don't have such a clause in the contract, in the Malaysian contracts, unless you can ask your client specifically, why do you need a multi-tier dispute resolution clause? The client must be able to give you the answer why they want that clause in. Is it because parties are in a joint venture, the project that's going to last another 4 or 5 years? That's why you have to have that clause in. Because most of the time, if parties were in dispute, they would go into ad hoc mediation or can be proposed by the lawyers. There's nothing to stop parties, even without a multi-tier dispute resolution clause, to say, can we go for mediation ad hoc? Let's appoint a mediator and try to resolve these issues, payment claims issues and whatever. So you don't have to be tied down with that stringent requirement where there's a possibility of condition, a precedent, possibility of time bar and whatnot. Parties are always at liberty to actually go for ad hoc mediation, unless the clients can tell you why they actually need this requirement of a multi-tier dispute resolution clause. Most of the time, from my experience, the client is not even aware of such a requirement in the contract, because when I tell them, hey, do you know you can't commence your arbitration now? They say, why not? Because I say there's a multi-tier dispute resolution clause. You have to set up a committee first, go through the committee, that's the first tier, and there could be directors from both parties. Then the second tier is then only you go for mediation. Third tier is you go for arbitration. Most of the times, I think the clients are not even aware of such a requirement, because it's just a boilerplate cut and paste clause they should have put in from other projects. That's my take. Thank you.
That's an interesting perspective. I think in the other presentation, Dashandev, you're speaking about, a CS saying, the contract's, locked in a cupboard. I haven't seen it. But so again, what happens is, in drafting the contract, the lawyers have put it in. But what role does sort of the culture play, Samuel? Perhaps what role does the culture play in the effectiveness of such clauses, and why people put it in the first?
I think culture plays a part in writing such clauses in Chinese-related contracts, because Chinese parties usually try to avoid litigation or arbitration. So they think putting in such a clause would be useful in having a tier in terms of negotiation or mediation. However, actually, as Hin Loong was saying and Jessica was saying, a first tier is really unnecessary. You can actually mediate or negotiate anytime, before or after the arbitration has commenced. You can resolve your differences along the way. So you don't really need to have a first tier in the first place. Putting in a first tier may lead to unnecessary cost and expense and delay. So On my part, I would say that it is really not necessary. Notwithstanding Asian culture or trying to work together with the other side to resolve differences, you don't need to put it in writing in the dispute resolution clause.
That's an interesting perspective. Mahnaz, do you have any thoughts on perspectives and how it's used in the UK and perhaps how culture impacts the use of such clauses as opposed to the Chinese and the Asian perspective shared here?
Thank you, Shahdy. Actually, I was going to try and play devil's advocate and take a slightly different view on the defense of multi-tiered clauses, since all the panelists had realized it was quite useless. I think my point simply is that in the UK, in litigation, what we have are pre-action protocols. So before you commence claims, you have to go through a pre-action protocol where you have to correspond to the party, tell them about your case, and to give that room for finding a negotiated settlement. And if you don't, then there are cost sanctions. And that's a really important tool to get parties to try and resolve their claims amicably if you can. Now, the problem we have with international arbitration is that we don't have such cost sanctions that you have in, at least as far as I know, English courts. I'm not sure if Malaysian courts or other courts have a similar protocol that if you don't, follow or try and attempt to settle the claim, then there might be cost sanctions. So with arbitration, we don't have that cost sanction. So in a sense, to attempt, or I'm using a harsh word here, force the parties to give settlement a chance, you create these artificial structures where you need them to talk at various levels, or you need them to have negotiations. And my point simply is that you do that because there are no cost sanctions. And that is a way of trying to give settlement a chance.
Thank you, Mahnaz. Samuel, perhaps you had some...
I just like to mention one features of PRC court proceedings is that you need to have mandatory mediation before you can file a case in court. So if you do not mediate first, you cannot file your proceedings in PRC court. In Hong Kong, after you have started arbitration litigation proceedings, the courts would also require you to mediate. If you fail to mediate, then there will be cost sanctions, unless you can give a very good reason why you refuse to mediate with the other side. So actually there's all along, there are numerous possibilities and opportunities for the parties to settle their disputes amicably, even though proceedings may have commenced. Thank you.
Thank you. I think I don't know whether there's any time for any questions. I think we have panelists flying out in the next couple of hours as well. But very quickly, I mean, if there's a question from the audience, please.
Thank you. A very interesting session. This question is addressed to Jessica. Jessica, you mentioned about the SPC. There's a directive way back in 2018 or something like that. But in view of the CND judgment, and you mentioned that in China there was a lot of discussion. Do you personally think that it is time to, for SPC to sort of think, more about it, and especially when there's so much foreign investment going to China, and I know China is civil jurisdiction. However, with all this ADR and a lot of ADR commission, they allow people to have the choice to have to opt into English rule, etc. So they will definitely be looking into cases like C&D. So do you think this is high time to sort of have a review? And I would like your own thinking about the C&D, because there's been a lot of discussion. I'm sure you're part of that discussion. Thank you.
Thanks, Sylvia, for the question. Of course, I'd like to clarify I cannot speak on behalf of the Supreme People's Court, and I wouldn't be able to tell you how it going to, whether it was revise its position. But actually, that letter I mentioned, or guidance, is dated 2008. But as a matter of fact, what I have explained is not that the Supreme People's Court in China is not pro-arbitration, but the opposite. It's very pro-arbitration, at least from the Supreme People's Court perspective, because the point, the conclusion of the court is, whenever they think this is not a jurisdictional issue, they don't even need to distinguish whether it's admissibility issue or jurisdictional issue, because they think strictly according to the law, the Arbitration Act, it is only whether it is a jurisdictional challenge or not. It is not jurisdictional issue, then the court is not bothered. They are not going to interfere either to invalidate the arbitration clause or to set aside or to not refuse enforcement. So actually that kind of rather broad brush approach is more to support arbitration, saying, I'm not bothered. You know, if this is more a procedural formality issue, and leave it to the tribunal, leave it to the parties. This is not jurisdictional objection, jurisdictional issue, which can invalidate the arbitration award or lead to non-enforcement. But I think the opposition, the position is actually very positive. So I don't think they need to really revise that attitude. But of course, I think to distinguish between admissibility and jurisdiction is useful when it comes to further discussions by the court. They may say this is a procedural issue, but it relates to admissibility only, so it's up to the tribunal to decide. If the tribunal already says it is admissible, then the court will not reconsider. I think that should be potential development.
Thank you. I think with that, with the time running, sorry. Okay, just one quick question.
Yeah. So we spoke about how dispute resolution clauses are either mandatory or permissive. In an ideal world, that would be the case. But also in that ideal world, there wouldn't be much for us lawyers to do. So more often than not, in my experience at least, the dispute resolution clauses are not happily worded. And you find words like may and so far as possible, things like that, which lead to more disputes. So both Mr. Samuel and Jessica spoke about how a dispute resolution clause ought to be worded to avoid these disputes. But I'd just like their thoughts on how to deal with a badly worded clause. How do they actually go about it? And because that's the situation that we actually face more often than not.
I would say if you face with the equivocal first-tier worded clause, then try to comply. Even though no notice is required, you send a written notice, so that time will start to run from the date of that notice. And make sure you mention, we have these disputes, so I'm serving you this notice to commence negotiation or mediation, and so on. So, and also importantly, I think the point of good faith, the claimant should not just send a notice and then sit back and do nothing in the interim. The issue is whether there has been good faith negotiation or mediation. So on behalf of the claimant initiating the arbitration, that party should do all its best to make clear that it has fully complied with the provision. Even though it may not be mandatory, you make sure there will be no future challenge that complicate matters. Thank you.
Thank you. I think with that, we will close this session. If there's any more questions on lunch break, we can always discuss and take this topic a little bit further during lunch. But I would like to thank my esteemed panel for joining me in this session. Mahnaz, it's very early in the morning. Well, it's not very early in the morning, but we thank you for joining very early in the morning your time, and thank you for the audience for this panel. Thank you again. Thank you very much.
Thank you.
Thank you to our panel of speakers and moderator for the insightful session. For those speakers who have joined us virtually, Ms. Mahnaz, we'll find a way to get a token over to you in London. I'd like now to invite Yang Berbahagia Datuk Sundar Raju, Director of the AIAC, to come up on stage and present a token of appreciation to our speakers and moderator who are here today. Ladies and gentlemen, warm round of applause for our panel. Thank you. With that, ladies and gentlemen, we've come to the end of our second session of the day. Without taking much more of your time, may I invite you all to join us for lunch at the pre-dining area at the lower ground floor. There will be ushers to guide you at the entrance. And as a gentle reminder, our third session will begin at 2:30 p.m. here at the auditorium. We'd like to see you back here. Thank you.